won't have to pay for that 50%, but for the other half 50%. And the last one, partial comparative negligence. Partial comparative negligence completely bars recovery if plaintiff's percentage of fault is greater than that of defendants. So if Mary contributes less than 50% of fault, she can claim for damages which is more than 10,000 US dollar. So we have around 2,000 US dollar of medical expenses, and we divide it into two. So we have more than 10 US dollars, 10,000 US dollars. And if Mary's contribution is greater than 50%, she cannot claim for any damages. So that's partial comparative negligence. So the three possibilities will vary upon the state that our Mary Elizabeth is in, the state that our Mary or Elizabeth is in. So we have the conclusion of applying US law is that Elizabeth is liable for Mary damage under negligence, but she also has a defense based on Mary's level of contribution to fault leading to Mary's damage. That's the end of my part. We're going to moving on to how do we solve the case under Vietnamese law. Thank you very much everyone for listening, and now it's Quang Minh turn.
So thank you. Yeah. So hi everyone. I'm Quang Minh, and in my presentation today, I will be discussing about the reason of the Vietnamese law, which regulate the situation of this case. So in my presentation will consist of two parts. And first of all, I will introduce to you some articles in Vietnamese law that we will discuss in this part. And the second is the applying of these articles to solve two legal issues of this case. So, okay, let's start. In Vietnam, so we have the same principle of law with the U.S. tort law called the non-contractual liability. And this principle of law is provided in the chapter 20 of the 2015 Civil Code of Vietnam. So to solving the problem of this case, I would like to introduce to you three articles which relate the situation. And I think that not all of you are familiar with this kind of law. So to make it easy to follow, I will give you the Vietnamese translation of all article that I will present in this part. So Bảo Ngọc, could you please come back to the previous slides? So the first article is the clause 1 of Article 584. The grounds giving rise to liability to compensate for loss and damage. So in Vietnamese, it's called căn cứ phát sinh trách nhiệm bồi thường thiệt hại. And the second is Article 590. The damage caused by harm to health, and in Vietnamese is called thiệt hại do sức khỏe bị xâm phạm. And the last one is Article 585, is Clause 4 of Article 585. The principle of compensation, that means the nguyên tắc bồi thường thiệt hại. So in clause 1 of Article 584, as you can see, a person harming to the life, health, honor, dignity, reputation, property, or other legal rights or interests upon another person, thereby causing loss and damage, must compensate for such loss and damage, unless otherwise provided by this court and other relevant laws. Move on, move on. Now. Hello, now move on. Yes, the next. Now we come to the first question of this case. The question is under the 2015 Civil Court of Vietnam. Is Elizabeth liable for Mary damage because she was using her phone while driving and then her car hit Mary's? So to answer this question, we will analyze the article 5A4, no, previously 5A4. According to the article 5A4, we have three elements necessary to establish a non-contractual liability. So the first one is an illegal conduct, and the second is the damage in fact or in practice. So the last one is the existence of the causal link between the one and two. And we will apply the Elizabeth facts to the elements. So we have an illegal conduct. In these elements, as you can see in the facts of the case, Elizabeth was talking on her phone while driving, and then she fails to stop for the red light. That means she violates the law of road traffic in Vietnam. So the second is the damage in practice. Mary suffered two broken legs and multiple cuts and abrasions in the accidents. And the causal link between the two is Elizabeth's illegal conducts are main reasons that make her fail to stop the red light, then rushing into beat her car and knocking Mary off her feet, which caused damage to Mary. So we can conclude that Elizabeth is liable for Mary damage according to the Article 5A4. And this type of damage is stated in the Article 601, the compensation for loss and damage caused by the sources of extreme danger. The next slide, please. Then we applying the resolution No. 3006 of the Churches of the Supreme People's Court to determine the amount of damage. The damages that Elizabeth had to pay for Mary comprise Mary's salary for 5 months, and I have calculated this amount, and this is $58,000. And second is the reasonable expenses for treatment. As you can see in the facts, the reasonable expenses for treatment is $20,000, and the total is $78,000. So this is a final number for Elizabeth. I think, of course, it's not, and that's bringing us to the second question. The second question is under the 2015 Civil Court of Vietnam, does the act of ignoring the downward signal and heading across the intersection of Mary reduce the total amount of damages paid for her by Elizabeth? So to answer this question, we will look at the article 5A5. No. Yes, we will look at clause 4 of Article 5A5. And this article states that where an injury party is at fault for causing loss and damage, such parties shall not be entitled to compensate for the part of the loss and damage arising from its fault. As is stated in the facts of the case, Mary ignored the downward signal and tried to head across the intersection. So that means she partly at fault for her loss and damage. And this article is close relation to the comparative negligence in US tort law. And and according to this article, the total amount of damages which is bet by Elizabeth can be reduced. Finally, I'd like to conclude by saying that the approach of Vietnamese law is almost like the US tort law, and that completes my presentation. And if you have any question, please raise your hand. Thank you for listening.
Thank you very much, everyone, for listening. So if you have any questions, feel free to raise the question.
Okay, thank you very much for the presentations from group 3. It's very comprehensive, right? Easy to follow, easy to understand. And they applied the tort of negligence, the normal tort of negligence, okay? And with respect to defense, they did raise the defense, right? Depending on stakes, okay? Whether the stake apply contributory negligence or comparative negligence, all right? So can you make it a little bit clearer? Yeah, waiting for other students to ask questions. I just want to ask questions. Can you make a bit clearer about the comparative negligence? So is it, yeah, can you make it clearer about comparative negligence? In what case comparative negligence will apply, and how many ways or how many types of comparative negligence, and how can you determine which one will apply into your case?
Okay, so can we get back to the slide? Is there any defense that we have contributory negligence and comparative negligence? Yes, thank you very much. Right, so under comparative negligence, we have two smaller types. The first one is pure comparative negligence, and the second one is partial comparative negligence. So as to partial comparative negligence, so this type of negligence completely bars recovery if a plaintiff, here in this case is Mary, percentage of fault is greater than that of Elizabeth. For example, we have 100% of fault, 100% of fault, and then if Mary contributes less than 50, if we could say 49% of fault, then Elizabeth contribute 51, isn't it? The percentage of fault that Mary contribute is lesser, is less greater than Elizabeth, so that she can claim for damages. But if the percentage that Mary contribute to the fault is more than 50, if we could say 51%, meaning that the percentage of contribution of Elizabeth is 49, so Mary could not claim for any damages. Get back to the pure negligence. So this type of negligence, meaning that the damage apportioned according to fault. For example, if Mary contributes 52, if we say 52% to the fault, then Mary can claim damages for the last 48% of the fault. So that's the difference between pure comparative negligence and partial comparative negligence. So actually, we divided these defenses based on, we don't know which state are they in, but we assume that the percentage of fault that which person contribute to the case is determined by the court or their investigation or their analyze. So we actually don't have an exact number or the exact percentage for each person to say which defenses that we would apply, to say correctly which defenses that we would apply to the case.
Okay, so assuming that states apply the 50% rules,
Okay,
assuming
50%.
so, and if you are a church, how can you determine the percentages in this case, okay? And what is your final judgment, okay, to resolve the case? Assuming that your stakes, okay, the stake that you are being a church, apply a 50% rules.
So does that mean that we applying partial comparative negligence?
Yep.
Okay. So can we have a few minutes to discuss?
All right, sure.
Okay, thank you very much. Yes, Miss.
Yes.
So we have the answer to the question. If we apply partial comparative negligence, then the percentage of fault that Mary has contributed is less greater than 50%, and we would say that it's 30%. We come to this conclusion using the but not test for Mary.
I'm so sorry. Using what test?
The but not test.
Okay. Just for applying, just for determining how many percentages or what?
We would like to explain that from the first question of the but not test, we come to conclusion that as a road user, everyone owns the legal duty of care to other people. Doesn't matter whether you are a pedestrian or a driver. Everyone owns the legal duty of care. However, if you are the driver, you use motorbikes or you use cars, we consider their duty of care is heavier than pedestrian because the omission to act or their act could more likely to lead to other injury. So the breach of duty of care of those drivers, in this case is Elizabeth, is greater than Mary. So the Mary's percentage to the fault is less than 50%, and we determine that is 30%.
You determined that the fault contributed by the pedestrians just about 30%.
Yes.
Okay, because you think that the one who ride a car could own the duty of care toward the pedestrians more than what the pedestrians duty of care, the level of duty of care owned by the pedestrian to what the car driver.
Yes, because the car drivers or the motorbikes user, the omission to act or the act of those users can more likely to lead to others' injury or loss.
So anyone else have different ideas about that opinion? What do you think? Anyone in the class have different ideas? This is just about opinion. Do not worry about whether it is right or wrong. It is more about whether which one is more like persuasive. Imagine the case where someone passed a red light in the traffic, busy talking over the phone. Can you show your screen with the first, actually the full questions that I sent you about the facts of the case?
Yes, it's on the screen right now.
Okay, yeah, all right, yeah. Thank you. Anyone have different ideas on that particular matters? Do you have different idea? Do you think that given the facts of the case, you could determine that the contribution, the fault contribution, the contribution with respect to fault of the patrons in this case is less than 50%. And for that reason, she can claim, okay, partial damage. And which means that the amount of damages that he could or she could claim is 70%, right? Of the
Yes.
total loss or damage. Okay. Anyone else have different idea? She took a quick peek. Okay, Mary took a quick peek in each directions, and despite the downward side, believed she could beat the traffic because the lights have just changed. So how much could you think that she could contribute to the negligence? Okay, so never mind, it depends on your argument. I don't think that it is very important, but yeah, you should take into account whether if you argue that the one who ride a motorbike or car could own more duty of care to those who actually the pedestrians, and you should consider more about the contribution on faulty elements rather than the general opinion that person who ride motorbike or who ride a car could cause dangerous to other person more than what the pedestrians can cause to the car driver or the motorbike driver. Because sometimes when a person who pass the roads immediately without looking around, and it may cause serious accident. So the fault contributed by the pedestrians in that case could be more than the fault contributes by the one who ride a motorbike or to ride a car, because it's actually according to the traffic rules, the car driver or the one who ride a motorbike have the right to actually to use the roads in that case, because whoever want to pass the road, especially even in the place, especially in the place that they know like traffic, you need to actually be careful when you pass the roads. And if you pass the road without looking around, and then you will be the one who contribute more fault than a person who ride a car or to ride a motorbike. You understand what I mean?
So the element that we base on to determine the percentage of fault is the traffic law.
Yeah, and also about the who make a mistake that caused the accident.
Okay.
Yeah, who make a mistake. But in this case, I didn't mean that Mary mistake is the important or key element, but maybe you can see here about the collision of the two cars, and also because of Elizabeth, right? The phone contributed by Elizabeth. Okay.
Yes.
All right. So we need to consider those factors as well. And maybe because three person, maybe how about the fault of Peter? What do you think about the fault of Peter? Whether Peter commit a fault or not?
From my personal point of view, I assume that Peter did not commit a negligence or fault because Peter followed the green arrow around the corner, and when he turned on the corner, it was all of a sudden that Elizabeth car from the intersection entered into the path, and Mary's was crossing the path with a no walk sign. So Peter actually did not breach his duty of care.
Right. Yep. Okay. All right, good. But I have another question for your groups. The last questions. Okay. The question for your groups is that assuming that the stakes that Mary take legal action against Elizabeth, in this case, likely that Mary will take legal action against Elizabeth, or maybe she also want to take legal actions against Peter as well. But my question is, what could be your answer or your argument if the stakes that she take legal actions doesn't apply contributory negligence defense?
So contributory defense is when the plaintiff who is partly at fault for his or her own injuries cannot recover, meaning that in this case, Mary has contributed a certain percentage of fault to her injury. She could not claim for any damages or recovers from neither Elizabeth nor Peter.
But how about the exemptions of class gear change?
The exemption of
Class gear change.
Class clear change is when the defendant, there's a chance for the defendants to reduce or not suffer the injury, but the defendant.
The defendant or the plaintiff?
The plaintiff, my bad.
Yeah.
The plaintiff does not do so. So this.
Okay, the plaintiff did not do so, or the defendant did not do so. about the class clear change. Class clear change is an exemption to the contributory negligence rules.
Yeah.
To what extent is an exemption?
Give me
Explain a little bit about that exemption of class clear change.
Okay, so allow me to say it again that under the last clear chance doctrine, the negligent plaintiff can, however, recover if he or she is able to show that the defendant had the last opportunity to avoid accident.
Yeah. Whether the defendants have an opportunity, okay, to avoid accident or not. And if the defendant have an opportunity, the clear opportunities, obvious opportunities to avoid the accident, and therefore contributory negligence defense will not apply. In other words, the defendant still have to pay compensation, even though in that state, the law applies the contributory negligence rules.
Okay, so we can get back to the slide of the fact, please.
Yeah.
Okay, can you present that, please? So here we could see from line 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, around 11 to 13, that's line. She was avoided more serious injuries since neither car was speeding off the time of accident, meaning that neither Elizabeth nor Peter was speeding at that time. Both of them were driving at a normal speed. And this fact could prove that either Elizabeth or Peter, they did all in their capacity to avoid injuries for Mary. So from this line, we personally come to a conclusion that we could not apply the last clear chance doctrine to the negligence, to the contributory negligence.
So may I argue that if Elizabeth did not using the phones when she was arriving, okay, she may not park the red light. and cross into the intersection would mean collided with Peter car. So is it a class clear change that she can avoid accident if she did not using the phones, talking to the phones during that time, talking on her phone? So did she have a chance to avoid accident by not talking over the phone? Okay, it's up to you, but I think that you should argue based on the facts given in the case. Okay, understand?
I understand.
Yeah, should argue several ways. Okay, so this is a presentation, so you should actually, based on the facts of the case, you should explore own facts given in the case. All right.
I understand.
Okay, good. Anyway, you did prepare very well for the presentation, especially you did interact with audience by asking questions, etc. And that it could be very good for you to do so in order to have an interaction. All right, good. And you did prepare very well, and you did actually answer all of the relevant questions to prove the tort of negligence, etc. But actually, for your case about the defense, I think that you need to pay more attention. It means that you could actually consider all of the facts given in the case in order to have a more persuasive answer to your question, especially with respect to defenses. Anyway, it's very good. Okay.
Thank you very much for your
Okay.
compliment.
Thank you. Okay. So last time, where did we stop at last time?
In fact, last time you said that we're going to have 3 groups presentation today.
Yeah. But last time, but yeah, I understand. But actually, I do not want to group second to the next group 4 to make a presentation right now because we are about to have a break soon. So I think that we should look at. I don't know what slide we stopped at last time. Do you remember? We look at several slides and then we have a break. And after the break, we will have the second group to make a presentation.
Okay, I understand.
Yeah. So last time, what slide that we look at?
We have the correction of, no, I'm sorry, my bad, supervening events under the determination of damages.
Yeah.
In the strict liability, chapter 4.
Yeah.
Yeah. It's down there. It's not up.
Here, right?
No. It's further. We have moved to the defense. The defense to product liability. And we were at the supervening. Yes.
Here, right? Yep.
Yeah.
We finished this, right?
Yes, we finished this slide.
Yeah. So the next slide is about contributory negligence. Okay. And usually, I have a questions that you look at the slide and could you please see why? Can you explain why contributory negligence can rarely, okay, use in case of strict liability? I'm sorry for minutes. We will have we think about this, but we have a break right now because I have someone to ask me some questions. So maybe we have a short break right now, okay? And thinking about my question, and you will answer that in the next section, okay?
Okay, Miss.
Okay, thank you.